Thank you for the invitation, the opportunity to talk with you about the rights of nature. I just arrived like 3 weeks ago, so my English is still exhausted. So as to know that, I will do my best. Um, so na- right now is kind of a common place to talk about Ecuador's role on this new movement of rights of nature because we approved um, a constitution in 2008 that introduces for the first time the rights of nature in a constitution. However, it has passed more than 14 years from that, and it is a good time to see what has passed in Ecuador after that recognition. We got a lot of other examples. We got a very interesting case in Colombia about the Trato River. We got examples in New Zealand, in India, and even in United States. In California, there's I think it's a county or a city that declares that the rights of nature. So a lot of things has been going on in all over the world about this. But what happened with Ecuador? I want to start this conversation talking a little bit about the rights of nature, what they are, and why this institution is a partnership in the relationships among human beings and nature. Um, First, I want to talk about the human right about human right of an environment, a healthy environment. Um, First, in the relationships, in the Western relationships among the human rights and environment, we didn't have a limit of those activities. We consider nature as goods, so it's something that is subject to private property and to exploitation. And basically, the development of the industrial society has based in the exploitation of nature. So when the environmental law first appeared was enormous advance to establish a limit on the human rights activities that are endangered nature. However, it was not. It is a piece of legislation that is still anthropocentric because the limits that we establish to the human activity is still um, depending on what the states want to recognize, and is always a conversation among economic activities, economical profit, and the impacts to nature. So at the end of the day, it will be a concession that implies maybe too much intervention in nature and the climate change and the rapid extinction of several species around the world shows that it's not enough what we are doing right now. So this the environmental law is deeply involved, is anthropocentric, that means that it's centered in human beings. And when lawyers try to present a case in environmental law, usually needs to show that a human being has been affected by the measure that we are challenging in courts, but without a human being involved, is very little what we can do in terms of protecting nature by itself and not in relation with human beings. So what rights of nature propose is a shift in this paradigm, trying to recognize that nature is not valuable because of the relationship that provides to human beings, but it gets a value by itself, and it's based on a couple of sources. First, we have we always talk about two sources. One that comes from indigenous people's view of nature as a person that is part of of their families, that they treated as ancestor, that and they got to protect nature. They believe, some of them believe that this mother, that nature is the mother. They believe sometimes that it's a god, or they got deeply practices, the cultural practices that depends on nature. So if we when we talk about rights of nature, we try to understand that relation between the indigenous peoples and nature and how that works. Um, oh, and the second source to talk about rights of nature is science, actually. And what we discuss with science is when we cross a line where there is no turning back in terms of the impact that human beings can produce to nature, when we extinct a species, when we pollute a river, among the capacity of the river to absorb that pollution, and it start affecting the life that the river supports. So in that aspect, when we believe when we believe is that the environmental law, the first line, the red line, is before the human activities before environmental law. What the environmental law establishes a first limit. The black arrow means the that human beings start to have limits that are defined by political, social, and economical interests. That is a limit. But rights of nature establish a new limit that is defined by the basically science. When we talk that there is no turning back about the extinction of a species or the pollution of a river, is something that we cannot negotiate with. We cannot talk with the river and ask it to have more tolerance to more contamination. We cannot discuss with this endangered species about, like absorbing or receiving more pollution. So that line is as Cormac Cooling, and a lawyer from Australia, says, is the laws of nature. Is actually something that we discover by researching what are the ecological cycles, what are the functions that the species got in the ecosystems, basically, and that allow us to understand when we are crossing a line that is too much for the ecosystem to absorb, to process. So what the Constitution of Ecuador established as the rights of nature are these three articles, Articles 71, 72, and 73, that basically states the right of nature to the integral respect of its existence, the maintenance and regeneration of its life cycle, structure, functions, and evolutionary processes, the right to be restored in terms when we got a highly degraded environment, and also these two principles that are very important, the preventive and the restrictive principles. That means that human activity should stop when the extinction of a species, the destruction of an ecosystem, or a permanent alteration of the natural cycles are happening, or there is the possibility that happen. That's the difference among preventive and restrictive measures. So that happened in 2008. In terms of the political times that we were living, we got a new government. We got the government of President Cordero that won the election and called for um, a constitutional assembly that established this new constitution. There's a lot of social movements and progressive political forces involved in drafting this constitution. But that doesn't mean that President Correa got the same point of view. And actually, what the environmental activists told us about the process of drafting the constitution was that basically President Correa was not aware of the impacts that these kind of changes could bring. And actually, they surprised themselves that this goes that far. But immediately after we approved the Constitution in 2008, we started having problems with President Correa's agenda on advancing oil and mining activities in Ecuador. Um, and sadly, we got a very depending constitutional court that was not independent, and that we got some research about this, and that basically the court tendency to decide in favor of President Correa's of the government is highly documented, and for 10 years, with President Correa sitting in power, we haven't had advance on rights of nature. We got very few decisions that do not address directly what the standards should be established about the respect of rights of nature. In 2019, we got or 2018, we got a referendum, and people decide to change some institutions, some people that were in the head of some several institutions. One of them was the Constitutional Court, and then we got a new court in 2019. And this court is the one that had decided the following cases that we will discuss now. So this all this is to give you some background about why we didn't have for 10 years any significant case about rights of nature. Now we will check 4 of these cases that I believe that are the main ones in terms of the new standards that we have about rights of nature. The first one is the mangroves forest case, and the mangrove forest is an ecosystem that plays in the coastal areas of Ecuador. It is not only Ecuador, but we are talking the mangroves in Ecuador. It is the habitat of crabs, fishes, shrimps, crustaceans, mollusks, insects, birds, reptiles, among other species. Is one of the most delicate ecosystems and important ecosystems in the planet. Is a source of food for millions of people in Ecuador, and is the work source for thousands of low-income people, especially African descendant communities in the coastal region of Ecuador. This mega diverse ecosystem absorbs 10 times the amount of carbon dioxide that a terrestrial forest do, and is a natural barrier to natural phenomena as tsunami and other climate phenomena that threat the coastal communities. This case arrives to the court because there was a lawsuit that it was a judicial review case of the environmental code. Judicial review, for those that do not know the term, is when you go to a judge and you sue a law, piece of legislation, and you ask to the court to review if the piece of legislation is complies with the Constitution. So this statute under analysis allowed some activities in the mangrove forest, but it was the environmental code that got some activities like tourism or communitarian tourism, or ancestral exploitation of mangroves, like the recollection of some of the species that are made by the communities, as you can see in the picture. Um, However, it got open statement that any other activity that the national environmental authority authorizes, it could be done in the mangrove area, and the only restriction is that they have to have a reforestation plan after the activity. So basically, you can cut all the mangroves, and some years after that, you can replant those, and there is not an easy process, as they said. So the ruling of the Constitutional Court decided that the mangrove ecosystem is entitled to rights of nature, and this um, the entitlement in law means that basically you got a person. Only persons are entitled of rights. So this is the first time that the court uses this word entitled. And one of the rights is entitled is the right of the respect of the existence and maintenance and the regeneration of the living cycle, the structure, functions, and evolutionative processes. And what that means is that in order to protect the mangrove ecosystem, the state got to take several measures, and one of them is established or clearly established in the legislation what kind of activities will be approved or allowed in this kind of ecosystem, and those activities got to have, even the approved activities got to have a program or a program or an assessment uh, an assessment study that allows to know what the impacts will be, and also the court established that the community that lives around the mangrove forest got also also the chance or should have the chance or the opportunity to be involved in the decision making process that involves how the state will manage the forest. So this is the first time when the Constitutional Court uses the preventive principle. That means that the stakeholders do not need to prove damage to an ecosystem. It's enough if they establish the danger of the ecosystem to the ecosystem, and that should be enough to the court. They don't have to scientifically prove that the ecosystem is in danger to ask to the state to have or to take measures to protect the forest. So that's the first time that the preventive principle was used, and also what the court says that is that this preventive principle should inform the state regulatory decisions. That is very important. The state cannot wait until the end of the activity to establish what the damages are. If there is the danger to affect these evolutionary functions, the cycles, the structure, the functions of the regulatory processes, evolutionary process of the ecosystems, then the government should stop the activity. The second case is the Los Cerros Forest, and this is a very interesting case. I can share with you the links of the hearing. The hearing was it was like 10 hours hearing, and the parties of the case just talked for maybe an hour, and after that, the other hours were amicus curiae talking. An amicus curiae is a person who got something to share with the court and wants to talk about the case with the court. So the court gives 5 minutes to the amicus curiae to talk, and then we got more than 8 hours of amicus curiae talking, and you can divide the amicus curiae in two groups: the mining companies lawyers and the scientists. And it was impressive how scientists from all over the world went to the court and talk about the findings that they had that they have produced, or the papers that they have published about this forest. So they talk about the fungus that they found and the function that they have in the tree communication system, and some of them show how there was some frogs that are unique of this forest, or talk about some endangered species that are listed in the IUCN endangered species list, like the spectacled bird, like uh, the the brown-headed spider monkey that is also in the list of endangered species. So um, it was kind of a biology class. It was very very excited, and on the other side you got these mining companies lawyers talking about that the law doesn't prohibit the mining extraction, and because of the state already gives permission to some companies to extract minerals from the forest, then it will be against the rule of law to move forward to those decisions. And there was a lot of warnings about international arbitration that will cost Ecuador thousands of millions of dollars, and well, there was a lot of just threats to the court about the impact that these kind of decisions could bring in the economical or in the economics of the budget of the state. So it was very interesting, and you can see that there were two different languages. The two groups were not talking each other, because if we go back to the graphic, what the mining lawyers were talking about is about the line that is established in the environmental law, what the state is allowing to do in the territory, and they were trying to sustain that if it's not illegal, then they can do it. But legality is a line that is defined by these political, social, and economical interests. But the scientists were talking about laws of nature, about the extinction of the species, about how the ecosystem will not cannot be or will be permanent affected by open pit minor mining in the area. This is a hotspot of biodiversity, the Cerros forest, and that was what the scientists were trying to establish in the court. This is also a very interesting case in terms of human rights, because the Cerros forest is settled in the Intag area, and the Intag area is the place of several communities that had suffered one of the worst experiences in a social environmental conflict. Some of the people from Inca have come several times to Cornell. Actually, we got a professor that was working very closely with Inca communities. They suffer several human rights abuses. The company hired paramilitary forces, for example, to attack the people living in the area. The communities resist very furiously to three mining companies. Even they burned a couple of mining camps, obviously not harming any human being. But it was a very strong resistance, And they used, sadly, every single case that they bring to the court regarding human rights. And probably the first victory that they had, it was in an international arbitration tribunal in which they can establish with the state that the company violate human rights, and that diminished the amount that the government got to pay to the company, because eventually the state retired the permission of the company because of the human rights abuses. But even though the company leaves the country with money in the pocket. So there was no way, after several years of litigation, to establish a prohibition to the state to approve mining projects in this area until the Cedros case arrived to the court. Um, what the what the court decided was first to declare that the rights of nature that correspond to Los Cedros forest were violated. And this is a very tricky wording if you see it, because it's not saying that Los Cedros is a person. It says that the rights that correspond to them were violated. And this strange wording was because there was no consensus in the court about a specific forest to have personhood. In the former case that we discussed about the mangroves, they were saying that the mangroves that is an ecosystem itself, it's entitled of personhood, and it's entitled of rights. But this one was in a specific forest in a huge ecosystem of cloud forest in the north part of Ecuador. But the decision voided the mining authorization in the area. They applied the preventive principle. They said that there was an overwhelming data about the impact of the mining activity in the forest that will endanger several species that are enlisted in the IUCN list for endangered species, and that is enough for the court to declare that no mining activity should be conducted in the forest. The case also started a national discussion on the impacts of mining and other activities that the rights of nature could cause. And actually, it was the first time that rights of nature get to the front pages of the main newspapers in Ecuador, but not saying we are the pioneers, like moving forward the rights of nature, but mining companies alerts on the decision of the court. So, and it was several pages like talking about how this decision could affect mining business in Ecuador. And also it's the first case that seriously put in danger profit of companies. And so it was a brave move for the Constitutional Court. And by now the decision is being implemented. So basically there is no more mining activities in the Cedros forest, but the redress of several deforested areas that were also that was also decided by the court have been implemented yet. So these are the jurisprudence about forest. We got a couple of decisions about rivers. This is the Akepi River case. The Akepi River is a Santo Domingo de los Sáchilas, a city in the center of the country. It's named by the Sáchilas indigenous peoples. It means a sloppy stone, Akepi. This case deals with the adjudication of water permits to a private parties that exceeded the environmental flow of the river. This environmental flow well, I'm a lawyer, so maybe I won't explain it properly, but basically means that you can use a certain amount of the water in a river without affecting the capacity of the river to maintain or sustain life. Basically, I hope I did it correctly. And what what the what the city of Santo Domingo was doing was giving more water amount to private companies. And what the scientists proved in the case were that that amount of water will provoke to the communities have have no water access first, and if all the parties take all the water that the city was allowing to take, then the river will be seriously impacted, and the species on the river will be in danger. So what the court decided in this case was first to declare that a kepi is is a subject and entitled to rights of nature, and that means that kepi is a person legally in legal terms, and their structure and functioning should be respected when the decision about their environmental flow will be taken. So basically, the environmental flow will should be the first idea or the first consideration for the city in terms of allowing other uses of the river waters, and that's the first consideration. Second consideration should be the communities living in the margins of the river and their necessities of the use of the water of the river. So local authorities should create a public policy to protect the river and to manage their flow, taking into account the communities living in the margins of the river. So it's also the decision also provides or entitles the communities a voice in the decision of these public policies regarding the rivers. And and the last case is the Monjas case, the Monjas River case. The Monjas River is a highly polluted river in the capital, in Quito, and is a different case in terms of the other cases because in the other cases we got nature to protect. This one is very much a dead river right now for the high pollution that the river has suffered in several decades in the city. So this is an issue of recovering the health of the river or the state taking positive actions to to recover the river. What the court decided is to also declare Monjas River as subject and entitled to the rights of nature. What means that the Monjas River is a person. It gives personhood to the Monjas River, and that the Monjas River rights were violated by allowing its pollution by decades, and that and a plan to redress the inflicted damage to its natural cycles got to be presented or got to be discussed by the local authority. That means the city of Quito. So the city of Quito should redress the river by adopting a public policy to restore the river, and that means probably discussions with the communities living in the margins of the river. Those are not uh, those are not peasants communities like in the Kepi River or indigenous communities like in the other cases. This is a city, so the communities in the margins of rivers are neighborhoods of people that wants to live close to a living river, and they got to be consulted and they got to participate also in the creation of this public policy to restore the river. So we have these four cases when we got the preventive principle in cases where there is no scientific evidence of an impact, but we got enough knowledge about the ecosystem in order to the state to take measures to prevent future pollution. We got cases where we know for sure we got scientific evidence that the actions of the state, especially mining, will impact the ecosystem when we apply the restriction principle to human activities that will endanger the species. And we also got this case when we already got uh, we already polluted, highly polluted a river, and the cases about recover the ecosystem. So these cases are the examples of what the rights of nature could look like in the practice. Some of them got already some effect in the two cases about rivers. We got the public policies that are being discussed in the cities with the participation of the community. So we at least got the first step in terms of redress and community participation. In Los Cedros Forest, we already got the voiding decision of all mining activities in that forest. So some advances have been achieved. So granting this personhood to rivers, forests, and other ecosystems can show to be helpful tools in terms of changing the burden of proof in trials. So, as we stated at the beginning, under environmental law, the plaintiffs must show that defendants have transgressed a regulatory standard, or they should prove damage inflicted to a human being. But once the personhood is recognized, the litigation could focus on the impact of the activity endangering the ecosystem. It also provides agency to communities living in or near the ecosystem as guardians of the rivers or forests, and that the conservation and redress are still duties of the state, but humans in interacting with nature are also invited to participate in the policymaking processes, and this is also something important. The preventive principle was applied in Los Cedros due to the overwhelming scientific data available. However, we do not know if the court will play a more active role in cases where the evidence of impact on the biodiversity or presence of endangered species is not available for communities or organizations. And that is the case of all other ecosystems. Maybe we got also the Yasuni Park that got a scientific station on it, and we got a lot of scholarly work produced about the Yasuni. But other ecosystems that are less scholarly study maybe doesn't have that kind of evidence that we can use in a litigation. So we will see what the court position in those kind of cases will be. It will be very it will be a scandal if the court with all that evidence will have failed against the rights of nature, but we don't know in other places of the country. In other conclusions, we got that in Los Cedros, the causality among mining activities and the extinction of endangered species was crucial for the court. But in other cases with more robust ecosystems, such as the Yasuni Park is a huge park in Ecuador. Is part of the Amazon River basin. the part of the Amazon basin in Ecuador. Um, how far should deforestation and pollution should get in order to trigger the protection of the rights of nature is something that we don't know. Um, Probably it will be too late, or should we wait until we got some species in the endangered list of the IUCN to trigger that protection? Or can we talk about preventive principle now in terms of all the studies that we have about the Yasuni as the most biodiverse hotspot in the planet? Is that enough for the court to say oil companies should be kicked out of Yasuni Park, or we want to wait until more pollution arrive to the park? So that is something that we don't know, and probably will be responding in future litigation. Also, to fulfill the promise of a paradigm shift in the relationship between humans and nature, the court should move from a degraded ecosystem approach in the jurisprudence to address the rationality of human activities in the impact to nature. And so to move more to a preventive approach than a reparative approach to nature. So animal cruelty could be a good starting point. Even if we don't talk about an ecosystem when we talk about animal cruelty, the approach that humans got with some domesticated species maybe will inform these limits, these ethical limits that human rights should have with nature. We got a full fighting case that I believe that will be very interesting in establish that line, because the people who are who want to recover bullfights in Ecuador establish some cultural rights because they are Hispanic descendants, and bullfighting is a very important expression of their culture. That is what they sustain in the court. And what the people who are against the bullfighting said is, and also that they are not putting in danger the bulls. So basically, if they kill 6 bulls in one afternoon, it doesn't mean that the bulls are in danger. But what the people that are against the bullfight say is basically is not the way that humans should be interacting with nature, in terms of this cultural expression means cruelty, and it's not the kind of rational relation that we should have with nature. If we understand nature as a person, if we understand the species that lives in nature as entitled of intrinsic rights, and we start considering humans as part of that nature, then we don't torture for pleasure to another human being. Then we should not be torturing an animal for pleasure of a human being. So I think even though it's a small case, if we compare that case with an ecosystem as Los Cedros or the rivers, probably in ethical terms will be very interesting what we should get from those kind of cases. Well, the shortcomings of this jurisprudence is that indigenous peoples are not part of the conversation yet. And even though we talk about that the rights of nature were inspired on the relationship that the indigenous peoples got with nature, the indigenous peoples haven't been involved in any of these litigations, and we still need to hear their voices in these cases. The other shortcoming is the political part, in terms of the comfort, how the constitutional court is formed right now. three of the justices that consistently voted in favor of the rights of nature leave the court in February of 2009. Actually, two of them were the ones to drafted or the decision for the court in these cases, and they are not there anymore. So we got three new justices, and we don't know yet what path are gonna take. They are gonna take, and two of the judges that consistently voted against these kind of cases are still in the court, and two other justices depend on the case. In some cases, they were in favor. In some cases, they were against the cases. So we don't know what the the shape of the jurisprudence of the rights of nature will take in the future. We got 10 years with no activity on the rights of nature, so we hope that the new term won't be like those 10 years. We hope that these 3 years, when we got these interesting cases, will set some precedents that the new court will follow. So that's the presentation, and I hope you got some questions and comments on that. Thank you.